Hello everyone. Today we are going to discuss a very basic and interesting topic in international law, jurisdiction. Now before moving further, let us take an example. This is Lockerbie Incident. In 1988, an aircraft was exploded in a terrorist attack. These were few considerations in the case. It was an American airline which was allegedly bombed by two Libyan nationals. This incident took place over Lockerbie, located in Scotland. It was claimed that maximum victims on the plane were French nationals. Also, it was later found that those bombs that exploded were loaded in Malta. So now the biggest question is, which country will have the jurisdiction? All countries claim that they have the jurisdiction. Now imagine you are a judge in this case. What will you decide? You can pause this video for a second and think for an answer. Is it difficult? Well, watch the video till the end, and in the meanwhile you will get the answer to this question. We will also discuss several kinds of jurisdiction available with a state. Meaning of jurisdiction. In ordinary sense, jurisdiction means scope or reach of a thing or activity. Now considering a bit technical sense, it means competence of court or legal authority of a state. In case of Dexter versus Commissioners of Taxation, it was found that every state has three kinds of jurisdiction: legislative, adjudicatory, and enforcement. Where legislative jurisdiction means that a state makes a law that covers its people, property, resources within its territory. As per adjudicatory jurisdiction, it means the courts can try anyone within its territory. And lastly, enforcement means that state can enforce its laws within its territory. Now, for jurisdiction, it is need to be understood that if something is happening within the territory of a state, there is no problem actually. Things will be governed by the state laws, state courts. If something which is happening between one or more states, then the actual problem arises. And these problems or these conflicts, they were resolved with the help of international law involving treaties or customs. What determines a jurisdiction of any state? Now we have few principles that establishes a jurisdiction. These principles are as follows: territoriality, nationality or also known as active personality, passive personality, universality, or last is protective principles. Now the first two principles are more state oriented, whereas last two principles are more crime oriented. These principles justifies the territorial and extraterritorial jurisdiction of the domestic court of a state. These principles are related to criminal jurisdiction of a state. It means that the criminal law jurisdiction revolve around these principles. If we talk about civil law, then international law does not limit states' jurisdiction in civil law matters, and a state can extend its civil law matters to another state through private international law. Territoriality principle. It is one of the most common principle that allows a state to reflect its sovereignty. As we have noticed earlier as well, in these kinds of jurisdiction, legislative, adjudicatory and enforcement, these all jurisdictions were related more particularly within the territory of a state. So this territory is one of the basic principles that establishes a jurisdiction. It is very well settled that anything which is happening within the territory of a state will be belonging to that state, and state have the right to exercise its right over that matter. State exercises jurisdiction on everything within its territory except those excluded by a treaty or customary international law. So for example, diplomatic embassies or high commissions, they are excluded from the ambit of the jurisdiction of the host state. As per Article 22 of 1961 Vienna Convention, it makes such missions inviolable and provides that authorities of their host states may not enter them without the consent of the head of the mission. Now, the territory of a state does not mean only the physical landmass, but it will also include its seas, airspace, or ships or aircrafts that are registered in that state. And if any activity occurs in these areas, they are considered to be happened in the territory of that state. Test of territorial jurisdiction. Now we have two situations here. If a crime is committed and ended in one territory, there is exactly no issue. But if a crime commences in one country and ends in another territory, conflict arises. Conflict arises as to which country will have the jurisdiction, because the territory of both the countries are involved in it. So in these kinds of situation, there is a solution that has been founded through objective and subjective test of territoriality. Objective test, also known as terminatory theory, means that a state can exercise jurisdiction if the offense is completed on its territory. Now this need to be understood that where offense has been actually completed, that territory can exercise its jurisdiction. But this is not that easy to determine. For example, in the case of R versus Blyth. In this case, the defendant, who was in Canada, wrote a letter to a 16-year-old girl who was in USA, persuading her to leave her home and come to Canada. Now it was held in this case that Canada cannot try this case because the offense was completed when the girl, under the persuasion, left her father's home. It could also be argued that this crime was completed once when the letter was posted in Canada. So now you can see there are two dimensions of this case, and it is not always easy or always precise to determine the completion of crime where did it took place. Next is subjective test, or known as initiatory theory, which says that irrespective of the place where crime has been committed or completed, the jurisdiction will prevail where the crime has been initiated. So this principle is important for trans-border crimes like terrorism or financial crimes. So ultimately, both the jurisdictions that where crime has been initiated and where crime has been completed will have the jurisdiction over that crime. However, considering all circumstances, court themselves will determine that in which state a substantial or more significant part of the crime in question was committed, because then it will be more easier to prosecute a crime. Effect doctrine jurisdiction. This doctrine is an extended version of objective test, which says that it is not necessary where the crime was completed, but where the effect of the crime has been felt. So imagine there is a bank in one state, it is being robbed. Definitely the effect will be suffered by the nationals of that territory, national of that place whose money is deposited in that bank. But take another example, where is a bank in state A and the money were deposited by the nationals of state B. If that bank in state A is being robbed, those people, those stakeholders of state B will be significantly affected by this robbery. This makes state B eligible to exercise its jurisdiction over the concerned robbery under effect doctrine jurisdiction. So it is not required that the constituent element of a crime should occur in the territory of a country, but what is required here is that the effect should be felt by the alleged country. Now this is the difference between objective test and effect doctrine, where for objective test offense need to be completed within its territory. But for effect doctrine, the effect should be felt and not necessarily the crime should be committed in the country. So, moreover, it is irrelevant that the offending conduct is legal or illegal in the country of its commission. It should have a significant effect in our territory. That is what required. Now, this doctrine was developed by United States by the adoption of 1890 Sherman Antitrust Act, which prevented the cartels present outside of United States affecting the market of the United States. So to prevent or to have jurisdiction over those cartels situated outside US, they came up with this doctrine. Now European state did not accepted this doctrine, but they also felt there are certain crimes related to competition that being conducted somewhere else, and European states were facing those effect. So they didn't agree with effect doctrine, rather they came up with a different approach of objective test. So in European wood pulp case, European Court of Justice not discussed effect doctrine, but they held that since the offense was implemented in Europe, thus it is considered to be occurred in European market. So as you can see the difference between European and US approach. Nationality principle. It is one of the least controversial principle among those five. It says that jurisdiction is applied not only to the nationals present inside the country but outside the territory of the state. Who are these nationals? So the nationality is acquired through birth, or even if the parents were born in that country, or through naturalization. It is the states who are responsible to establish criteria for determining the nationality of their citizen. So this principle becomes important when the other state where our national is residing have refused to try a crime, maybe for the reason that the act was not illegal in their country, or for the fact that they are not interested. Therefore, the state of which that national is belonging can try that person. The idea behind this principle is that no crime should go unpunished. One cannot evade legal consequences of an act that is a crime in her or his state. So this principle is very useful to prevent doctrine of evasion, which means national of one state moving to another state seeking or getting themselves indulged in certain acts which are not permissible in their country. So for those instances, this principle applies and state can have its jurisdiction. Protective principle. Now, to protect the vital interest of a state from harmful acts of its national or foreigners done within or more often outside the country, this principle has been evolved. Let us understand this principle with the help of a case, United States versus Zehe. Now in this case, US government brought a criminal prosecution under Espionage Act against Alfred Zehe, an East German citizen, for alleged act of espionage against United States committed in Mexico and German Democratic Republic. Now Zehe pleaded this act does not have jurisdiction to cover his acts of espionage committed outside US and moreover on non-US citizen. But the court said that US had a jurisdiction over acts committed abroad even by its own national or foreigner, which threatens the security of the United States. So if someone is indulged in any act that meant to threaten the security or operation of the governmental functions, that person can be held under this particular principle. So activities including espionage or broadcasting dangerous propagandas against a country will be covered under this case. Now it might look that this principle is similar to effect doctrine jurisdiction. However, there is a difference. The difference is that in effect doctrine, effect need to be felt in the territory. Here, the requirement is the interest, security or functioning that need to be threatened by the crime wherever they are located. So crimes involving crime against seal, currency, passport or public documents can be included under this principle. It is also need to be understood that this principle is being often misused by the states by bringing irrelevant entries in their list of crimes causing threat to security, territory or political independence of state. Universality principle. Now there are certain crimes over which all states have jurisdiction. It is the nature of the crime that decide universal jurisdiction. In fact, states need not to be a party of that crime. There need not to be any link between them and state. Still, they can exercise their jurisdiction. Such crimes are piracy, slavery, genocide, war crimes, crimes against humanity. The fact that the criminals are hostis humani generis, anyone can prosecute them. The purpose of this principle is that perpetrators of serious crime should not escape. This principle was recognized in SS Lotus case. In arrest warrant case, Belgium claimed universal jurisdiction to prosecute the alleged crimes. However, court did not pronounce whether Belgium was right in establishing universal jurisdiction or not, but held that the arrest warrant issued by Belgium violated the immunity of the accused person. Trial of Adolf Eichmann was one of the earliest cases where this principle was applied. In this case, Adolf Eichmann was brought before the Israeli court where he pleaded that Israel had no jurisdiction since he was not Israeli, since crimes were not committed in Israel, since Israel did not exist at the time of the crimes. Moreover, legal base for prosecution was created after the alleged crimes were committed. So therefore, Israel does not have a jurisdiction, to which the Israeli Supreme Court held that the nature of crimes of which Eichmann was accused justified the extraterritorial jurisdiction of Israel. So this is how universality principle was brought into this case. Now the big question is, can any state prosecute for any crime? Is it that easy? The answer is no. States which are having territorial jurisdiction will proceed. If they are not able or refuse to prosecute, then another state can come into picture. Lastly, there is a controversy attached to this principle. Since it does not have a validity under international customary law, it is difficult to apply this principle. Last is passive personality principle that allows a state to prosecute foreigner whose acts affects nationals of that state abroad. Now it will look similar to effect doctrine since act is done from abroad, but it is different from effect doctrine since in effect doctrine effect need to be felt by the state claiming jurisdiction. Here only the national of that state is a victim of a crime. Further, crime is not done in the territory of claiming state. Effect is to be felt in the territory of the claiming state. So these are few differences that we should keep in mind. Now there is a very prominent case, the Cutting case. In this case, Mr. Cutting published some libellous material in United States against a Mexican diplomat. When he approached Mexico, he was arrested on this same principle that he being a foreigner did something abroad, that is US, against our national, where our national was a victim. So this was the ground for Mexico to arrest or to prosecute Mr. Cutting. So if our national is a victim in certain case, definitely our state can prosecute the concerned perpetrator of the crime. Now Guatemala genocide case laid down two tests for the application of this principle. The first is that victim must be the national of the state, and secondly, there should be a relation between the crime that has formed the base for this jurisdiction inflicted upon the national of the state. It means those crimes which were used to establish the base for the jurisdiction, those crimes must have been inflicted upon the nationals of a state. If this requirement is fulfilled, then this principle can be applied. Now, this principle promotes a jurisdictional conflict, that when some crime has been committed abroad, definitely that state where the crime has been committed would more likely to apply its territorial or nationality principle to have the jurisdiction. So, after going through the concept and principles of jurisdiction, let me place everything in a line. First of all, the general principle of a criminal legal system is that no crime should go unpunished. Jurisdiction helps the state to prosecute the offender once a nexus is established through any of those five principles. Secondly, all of these principles are placed in the domestic laws to allow state for exercising its jurisdiction. For example, Section 3 of Indian Penal Code provides jurisdiction based on nationality principle. Next, all those states entitled with jurisdiction can proceed in a case. A state exercising extraterritorial jurisdiction by investigating and prosecuting a crime on the basis of one of the acknowledged jurisdictional principle is not violating international law, even if the crime is already investigated or prosecuted by the authorities of the state where it was committed. Now you will ask whether it invites double jeopardy. So the answer is no. The principle of double jeopardy is not violated here, since it gets activated after the decision of the court, not at the stage of investigation. Moreover, there is no hierarchy present among the criminal jurisdictions. However, territorial jurisdiction is still followed as a matter of policy over universal jurisdiction, because there is a more likelihood of availability of evidences and witnesses on the territory of the commission of the crime than any other state. So, for the convenience of justice, territorial jurisdiction is practically preferred over the others. Only when the state of territorial jurisdiction is unable or unwilling to prosecute, the other state can proceed. Lastly, you cannot prosecute an offender until he or she is present in your territory. For example, a German national committed a murder in Germany and stayed there. Hence, Germany can try easily. But consider, if a German national committed a murder in Germany and fled to France, then how Germany will be able to prosecute him now? Germany will not be able to exercise its jurisdiction until the offender comes back to Germany. Now the question is, how will he come back? To answer this question, let us understand the last part of our video, that is enforcement of jurisdiction. So how to proceed when we have a jurisdiction but an offender is not present in our territory? This can be done through three ways. Firstly, through extradition treaties. Countries sign extradition treaties among themselves so as to facilitate the extradition of accused among themselves. Secondly, if there is no extradition treaty present between the states, then with the advance consent or acquiescence of the other state, the presence of the accused can be secured. Thirdly, if the other country themselves deem it appropriate for the sake of justice, they can deport the accused to the state where they have committed the crime. Now, apart from these three legal measures, one illegal option is often practiced by states, that is abduction. It means to abduct the accused from the territory of a state where he or she is hiding and bring her or him back to their own territory without the knowledge of that other state. This is considered to be an illegal enforcement of jurisdiction, since it violates the sovereignty of other state. Now, one thing you should understand, that enforcement of jurisdiction involves a lot of diplomacy and much is governed by the international relations between the parties. So, with these measures, state secured the presence of accused in their territory and then proceed with the prosecution. However, the illegal capturing of accused is highly problematic. It raises a question that whether the state will still possess jurisdiction after abducting the criminal from other state. Well, the practice of court reflect that in the cases of illegal capturing of accused, the jurisdiction to the state is generally declined since the presence have been secured in violation of international law. Now let me quickly answer the question which I have asked in the beginning of this video, that is, which court will have the jurisdiction? So as we know, the place of commission of crime was Scotland. Therefore, Scotland claimed the territorial jurisdiction, but the alleged accused was present in Libya after the incident. Therefore, Libya started their prosecution based on Nationality Principle. US and UK did not wanted that to happen. They started putting pressure on Libya to extradite the accused. Later, case took an interesting turn when Security Council came up with resolutions that left no option before Libya other than to extradite the alleged accused. Ultimately, in this case, under a special arrangement, the two Libyans were tried in the Netherlands but in front of Scottish court with 3 Scottish judges bench and under Scottish law. I hope you have enjoyed watching this video. I'm sure it must have provided answers to some of your questions. If you have any further query, kindly mention them in the comment section below. See you in the next video. Thank you.